Let's talk a little bit about intellectual property and the rights that goes along with intellectual property. First, probably important to explain what intellectual property is. We have a bunch of videos on this, so probably watch those. But if not, intellectual property is going to be trademarks, copyright, and patents. We're not going to be talking much about patents in this video. We handle copyrights and trademarks primarily. So, intellectual property includes both of those things. And with intellectual property, you have the ability to either give people ownership over that intellectual property. I'm going to probably refer to it as IP in this video. You can give people ownership of that IP, or you can license a limited usage right for that IP. And those are the main two options when it comes to intellectual property. Now, a lot of the time people confuse these things. A lot of the time when you enter into a contract, maybe you're a creative and you're creating logos or you're creating videos or photos, and the other side expects ownership of those. And you are only going to license it to them. That is something that happens often because people that don't understand the creative industry just assume that if they hire you, they get ownership. And in fact, the default law says that when someone hires you to make creative content, you actually own it as the creator, as the author, unless you have something in writing that assigns the ownership to who hired you or whoever wants it or whoever you want to give it to. So let's cover ownership, that assignment, first. Assignment has traditionally been called work for hire. We don't use that language anymore because it actually infers an employment relationship, and a lot of the times in these relationships where someone hires a design agency or a vendor or a freelancer to create IP for them, it's not an employment relationship, and you have to be careful with that language. So assignment of the intellectual property is what it is called when you give someone ownership of that intellectual property. Now, this might be straightforward to some, but it's worth reiterating and making sure it's clear before I go to what licensing looks like. Because when you assign ownership, it means that you give it up. It is no longer yours. You have no say over it. You can't use it, even though you created it, and you can basically do nothing with it whatsoever because who you assigned it to has full ownership and all of the rights to do whatever they want with it, however they want, for as long as they want, wherever they want, whenever they want. They own it. Just like if you sell a car, you're not going to go still use that car. It's theirs to use however they want. Now, licensing, on the other hand, is very different. And I encourage our clients, when you have two different scenarios, you should charge more for ownership because you're giving it up. Licensing, on the other hand, if you license, you keep it. You still are the owner, but you let someone use it. So you can think about renting a car. They've got those apps now where you can rent your own car out to other people. That's the same as licensing. You're letting someone use that car for a limited period of time under a certain number of miles and in certain ways with certain rules and parameters. You know, don't go to the beach, don't get sand in it, don't smoke in it, things like that. Very much the same when you give a license for the use of intellectual property. The difference is you're not going to tell someone not to smoke in the photo that you made because that's not physically possible. But you can tell them don't use that photo for bus benches or wrapping limousines or airplanes that fly with banners. But you can use it for your social media and your website. That would be an example of limiting the type of usage of the IP for that party, for that person. Now, you could also say that you only get to use it for 1 month or 1 day or 10 years. Totally up to you because you're the owner licensing that. Another thing that you can say is that you're not allowed to let anybody else use it. You don't have the right to sub-license from your license to other people for other uses. You can also require that with that license, they pay you royalties every time they use it, or every time they sell it, or every time they make money off of whatever that intellectual property is that you created for them. You get to make money because you put it in the license and it's part of the license's terms. Another thing that you can put in there is you can limit it to a geographic region. Let's say you only want someone to use the IP you created in the United States. Maybe that's because you have another license in Europe and you don't want those to conflict because each person got an exclusive license, which is something else to cover. You can give multiple licenses out of the intellectual property that you've created. So let's say that I created a super cool striped shirt and I wanted to license the design for people to manufacture it. Well, let's say I license it to someone in Europe, someone in the US, and someone in Central America. Well, I would want them to have exclusive licenses for their region to use that design to produce that shirt. And then that would allow each of them to feel safe that in their region, they're the only one with the right to use that intellectual property. If you made it a non-exclusive license, that means I could give more licenses to other people in those regions, wherever I want, to be able to do that same thing with that design. And that's a good example of exclusivity versus non-exclusive, and another way that you can limit and put parameters on the usage of IP under a license. Very important, because there are a lot of different things that go into this. For instance, you can have an irrevocable license, meaning that it's a license that someone can use forever, can't take it away. That kind of sounds like ownership, right? It is, but because it's a license, you also have the right to use whatever that IP is, while they do also in perpetuity because it's irrevocable. You can also make it a revocable license. That's what I always recommend. Make it a revocable license and put the parameters that I've been talking about on it. You can add other parameters like don't use this for something that is immoral. Don't use this to support gambling. Whatever it is you choose, you can put those parameters on your license. And then if they're violated, if you create a photo and someone goes and uses it for a casino when you said no gambling, you can revoke that license and they can no longer use it. Then it would be unauthorized use of that IP, which is actionable at law. And this is also important because there's things that can go into this as far as if somebody's using it, like I said, unauthorized. Well, if you worked with someone and you both created IP together, but let's say there was one thing that you created and you never had a license, you never had assignment, there's no agreement that lists what that actually looks like between you, and that other person's using it. That isn't allowed. You created it, it is yours, and you never gave them a license, you never gave them ownership. Super important, and the way that I would wrap all of this up is that you need something in writing. You need an agreement, whether that's an assignment agreement or a licensing agreement, or let's say it's a consulting agreement or a services agreement or an independent contractor agreement that lays out all the other things you're doing. In that agreement, it should have the license or the assignment within it, if you don't have just a license or assignment agreement. Very, very important, because with intellectual property, almost always, what we assume would be the case is actually not legally what the case is. And so that writing, that written agreement is so very important, especially if you're giving a license, because you want to make sure that you put all those parameters in there and that those are exactly what you need them to be for that person to use that intellectual property. So this is all about ownership, licensing, the rights that go with intellectual property. And to quickly wrap up and give you a little bit more on intellectual property, that can be anything from logos to names for businesses and brands, to photos, to script treatments, to books, to movies, to board games, to anything, stickers, really anything, songs, lyrics, music compositions, all of that is intellectual property, and all of that falls within what I'm talking about here. And you can also keep in mind that things like copyright, so books, photos, things like that, you can give out multiple rights. That's where things like Harry Potter have come from. Originally, the book was written. That's something that was protected under copyright. And then from the book, rights were given for an amusement park, for merchandise, for movies. All of those stem from the original copyright and were licenses for people to use the intellectual property in a very specific way. Hopefully this has been helpful. Thanks for tuning in. See you again sometime.